Hi, I'm Huntsville, Alabama criminal defense attorney Andrew Siegel of Siegel & Siegel. Today's topic is what you need to know if you're accused of possession of marijuana. The first thing you need to know is that there are two different degrees of possession of marijuana. The most serious is possession of marijuana in the first degree. There are two ways that this particular crime can be committed. It can be committed by a person who has a previous conviction for possession of marijuana in any degree, and if a person with a prior marijuana conviction is found to be in possession of marijuana a second time, that would be treated as a felony, or possession of marijuana first, which is a felony offense. So if somebody had a 20-year-old possession of marijuana for, a joint, and they were caught 20 years later with another joint because of the prior, that is treated as a felony possession of marijuana under Alabama law. I understand a lot of people don't like that. I'm not saying it's fair. I'm saying that's what Alabama law, in their wisdom, if you want to call it that, has decided. The other way that a marijuana first or felony marijuana case occurs is if the marijuana is for other than personal use. So looking around for something as a substitute to this is going to be our stand-in for the marijuana blunt. Police pull over someone, let's for the sake of this argument assume that it was a legitimate pullover, and guy has a blunt in his car. Cop says, "What you doing with that?" Fellow says, I'm going to a party and we're going to smoke it up." Had the guy just said, "It's my blunt and I'm going to smoke it," it would have been a misdemeanor possession of marijuana. But because it's for other than his own personal use, he has now said, "I'm going to use it with my friends." Other than personal use elevates that to a felony offense. Oftentimes police officers will say, "Oh, well, gee, there's 3 bags of marijuana," or "there's a bag and some scales," or something like that, and they'll try to pump it up and say it's a felony because they'll assert, "Gee, it's for other than personal use." Or a person might make a statement of, "Hey, I got a sack of weed, but I was going to a party with the weed. We were going to a party," or something like that. In those circumstances, law enforcement, whether it's the prosecutor or the cops or both, may try to take a case and say, "Oh, because it's for other than personal use, it is a felony offense." And a felony marijuana case carries a range of punishment of a year and a day to 10 years in prison. Pretty serious, for, in my view at least, for a marijuana case. The lower type of marijuana case is possession of marijuana second degree. Possession of marijuana second degree simply means that a person is in possession of marijuana for their own personal use. So if I've got a joint to smoke up and it's my joint, that's possession of marijuana in the second degree. Any possession of marijuana, whether it is a felony or a misdemeanor possession of marijuana case, they have to prove that the person is in knowing possession. That simply means, what it sounds like is that they have to know about the dope. So if this jacket that I'm wearing, if I borrowed it from some other lawyer to make this video and I'm fishing around in the pocket and I go, "Well, holy cow, there's a sack of weed in here," and some guy is collecting for the policeman's ball and knocks on the door and opens it up and I'm standing there with, somebody slipped a turd in my pocket, technically the argument would be, "Well, I'm not guilty because I didn't know about it." So it has to be knowing possession. And that kind of issue comes up quite a bit, most frequently in automobile cases where, there's 3-4 people in a car and there's dope under a seat and magically nobody knows about it, and cops say, "Hey, we're going to bring you all in and let the judge sort it out." Well, and that's what will happen if there's a trial. They'll have to decide, well, whose is it, who knows, who doesn't know, etc. It also happens in cases where there's a drug raid and there's a bunch of people and maybe there's some dope under the cushions of the couch or something like that. But they have to prove that it is a knowing possession. There are other issues regarding possession that you need to know if you or somebody you love is accused of possession of marijuana. One of those is that there are different types of possession recognized under Alabama law. let's start with the basic, which is direct possession. I am in direct possession of this pen. It's pretty clear. It's my pen. Direct possession is that it is obvious proof because I am directly in possession. If you'll look, or let's make it a little bit more obvious, there is circumstantial possession. I have a mark on my hand. That's a pen mark. From the circumstances, they can put together that, oh, that's probably Siegel's pen. Same ink, everything matches. And so they can try to put that too. There's another kind of possession which is called mutual or joint possession. And that is where, let's say I go to the movies with my wife and we get a thing of popcorn and we are sharing it. Prosecutors can say, well, it's both of theirs. And if let's say instead of a thing of popcorn, I got a sack of weed. Well, if there's some shake on my shirt and some shake on her shirt, if they can prove beyond a reasonable doubt that we were both sharing it, we could both be guilty. By the same token, I, as a defense lawyer, could argue, hey, this person didn't know about it, and if that's believed, one person can be found not guilty, another person can be found guilty, or both. And I forgot to mention on this earlier with the hand, that's also called constructive possession. And all that means is that from the facts and circumstances, if the jury or judge, that is whoever's judging the facts, if they can construct from the evidence that the person was in knowing possession, that can be enough to convict. Another important thing about Alabama law that, I'm getting a little bit political here, but that I think is stupid, is under Alabama law, to prove that the substance is marijuana, all that is required is that a sufficiently qualified law enforcement officer testify that, yep, it's dope. Used to be that to establish that the substance was marijuana, that they would send it off to a lab and a qualified toxicologist would run it through the lab tests and say, well, gee, there's the presence of THC. They do other things. They might, subject it to a chromograph or other things and determine it. Now it's basically a cop saying, looked like dope, smelled like dope, I'm qualified and it's dope. If the judge or fact finder, jury or judge thinks that's good enough, a person can be convicted based on that. Personally, I think that's awful and I think that's stupid. I think that opens up the door to some cross-examination on those grounds. Pretty basic stuff like, well, wait a second, officer. You found some dried material. Yeah. What makes marijuana is the presence of the THC, the stuff that the person gets high off of. You didn't smoke this stuff, which I doubt that the cop's going to say you did. You didn't smoke this stuff. You said there was some seeds or things you presumed were seeds. Did you plant it to see it? Oh, you didn't do that. You did some chemical. Oh, you didn't do any chemical tests. Microscopic tests to determine if there were cellulose walls to see if it was a plant. Oh, no. Okay. Well, do you know what kind of plant? You said that it's a plant, but you didn't test it at all. Well, marijuana is a plant, right? Okay, well, so we agree on that. What kind of a plant? Isn't it a dicot? It has two leaves when it sprouts? You don't know. How many types of dicots are there? Aren't there like 3,000? Oh, you don't know. I see. Well, and you didn't do a test to see if it had cellulose? Well, no. Did you do a DNA test to see if no, you didn't do that. But you say you think it's of a hemp. Of course, you didn't test this to see if it was hemp, etc., etc., etc. And you can do a pretty good job cross-examining these guys who claim to have sufficient knowledge. The problem is, since most of the marijuana cases are district court or lower court cases, is if the judge doesn't care, if the judge says, he's sufficiently qualified, we can do a wonderful job cross-examining, but if the judge is going to just sit there and go, here's good enough, you still can lose on that. I think, and again, this is just me pontificating, I think that juries will be more willing to listen to those arguments. The reality is that on many marijuana cases, prosecutors say they recognize it's a marijuana case and are more willing to try to resolve these cases without the need for a trial, either by some sort of counseling or some other disposition. It may be that they don't want to get into those issues by having a trial, but many of the marijuana cases have resolved without the need for a trial. Another thing you need to be aware of in marijuana cases is if you are convicted of a possession of a marijuana case, you will lose your driving privilege and you will lose it for a period of 6 months. That's not the judge being nasty. That's the state of Alabama says, hey, drug case, we don't think you're safe to drive. The Department of Public Safety is going to take your driving privilege for a period of 6 months. You're out. Misdemeanor marijuana, I've talked about the punishment on the felony. Misdemeanor marijuana, the range of punishment, depending on the court. If it's a municipal court, the maximum sentence is 180 days. If it is a district court, that is if it's in state court, range of punishment is up to a year in jail. That's not to say that that's what's going to happen to you, just talking about the maximum here. If you or somebody you love is accused of a possession of marijuana case, whether it's misdemeanor or felony, really the smartest thing you can do is talk to an attorney and do so as quickly as you possibly can. Obviously, if you want to talk to us, feel free to give us a call. When you talk to us or any other attorney for that matter, any conversations you have with that lawyer are confidential and privileged. It's not that us lawyers are such wonderful, nice guys on that. That's the law. We are not allowed to talk about what you say to us, and that's meant to give a person who is accused of a crime or who needs to talk to an attorney an opportunity to talk in confidence with a lawyer. Our view at Siegel & Siegel is that if you're wanting to talk to a lawyer, you shouldn't have to pay for that initial consultation. You shouldn't have to pay to decide if you want to hire a lawyer. Our thoughts are, you know, if you had to pay to go into Walmart to look around to decide if you're going to shop there, why would you go in? So if you want to come in and talk to us to decide if you're interested in hiring us, just come on in and talk to us, and if we can reach an agreement where we think we can help you and you're interested in us helping you, then, you know, we'll talk. Whether you hire us or you don't hire us, I hope this video has been helpful. My point here is to try to provide some education to folks about this area of the law. Our number is below, and I hope you found this video helpful and informative. Thank you.